Supreme Court of India Pawan Kumar vs. State of Uttar Pradesh and others, decided on November 21, 2023. SCC Online SC 1492, facts of the case. On December 1, 1995, father and brother of the complainant, Guru Prasad Mishra, were irrigating their land. Water flushed towards the adjacent field belonging to one Gaya Prasad Mishra. Prasad Mishra reported this to his father Gaya Prasad Mishra, and shortly thereafter Gaya Prasad Mishra along with his two sons, Gulab Chandra and Pawan Kumar, the present appellant, and one, Babadeen, came to the spot armed with ladis, and started assaulting the father and brother of the complainant. This incident resulted in grievous injuries on all and ultimately in the death of one Ganga Prasad, brother of the complainant. Trial court convicted appellant offences under sections 302 and 307 read with section 34 of IPC. Findings of the court: undoubtedly, the appellant belongs to the aggressor group and had attacked the deceased and caused injuries and ultimately the death of one of the injured persons. The present appellant were armed with ladis. It is also not a premeditated cold-blooded murder. The claim of juvenility, even if the medical report which shows the age of the appellant as 19 years is taken to be correct, even then in a case where an exact assessment of age was not possible, considering the conflicting reports and documents, the provision given in sub-rule 3b of Rule 12, Juvenile Justice, Care and Protection of Children, Rules, 2007, would come into play, and the court ought to have given the appellant a benefit of 1 year in the present case. The role assigned to the present appellant is no different than the role assigned to the other two accused who were convicted under sections 302 and 307 read with section 34 IPC. It is exactly the same role, and clearly section 34 of the Penal Code, 1860, is also attracted. The conviction of the appellant is sustained under sections 302 and 307 IPC read with section 34 IPC, but all the sentences which have been awarded to him are hereby quashed, as such sentences cannot be given to a juvenile. In view of section 16 of the Juvenile Justice Act, 2000, the appeal is partly allowed. The appellant has already been declared a juvenile in view of sections 15 and 16 of Juvenile Justice Act, 2000. Since the maximum period for which a juvenile can be detained is 3 years and the appellant has already undergone imprisonment for 4.5 years, we hereby order that the appellant be released forthwith, unless he is required in some other crime.